Well, good afternoon or good morning, depending on where you're joining us from today. My name is Mona Adabi, and I'm an associate in Thompson Hine's Government Contracts and Privacy Practice Groups. I would like to welcome you to today's webinar. This is the 7th in a series of webinars examining what this shift in presidential power could mean for the country. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the questions box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can at the end of the webinar. We will be offering CLE credit for today's webinar. Please make sure to fill out and return the webinar affirmations form that can be found in the handout section of the control panel, located on the right-hand side of your screen. The form provides instructions as to where to send the completed form. You'll need a tracking code, which I will provide, which I will announce at the end of the program. In the handout panel, you can also download a copy of PowerPoint slides and bios of today's speakers. So here's the format to give you an idea of what to expect. Today, we have an amazing panel on practical advice for antitrust and privacy compliance in the Biden era, where we'll be talking about the big trends we need to keep our eyes on that could directly impact your business. After I take a few moments introducing each of the panelists, I'll kick off the conversation, asking questions that draw out some of the high-level themes and trends we should be thinking about. Again, thank you for your interest, and if you have any questions as we go along, please use the questions box. I am delighted to introduce my Thompson Hine colleagues that will be participating in our panel discussion today. Joining me today are Joan Meyer, a partner in the white-collar criminal internal investigations and government enforcement practice, Matt Ridings, a partner in the antitrust, competition, and distribution practice, as well as a certified compliance and ethics professional, and Tom Zych, a partner in and chair of the firm's privacy and cybersecurity practice. And with that, let's get started. So first, Matt, antitrust law has been in the news a lot lately because of the lawsuits against big technology companies like Google and Facebook. Now, these lawsuits are certainly a significant development, but outside of the tech industry, should we expect any major changes to merger enforcement under the Biden administration?
I think there's a popular expectation that there's going to be much more robust merger enforcement with the Biden administration than with the past Trump administration, but I don't expect there to be a sea change. The Trump administration has actually been pretty aggressive in the merger enforcement during its term, and particularly towards the end of the term, had really started to take on some interesting M&A cases in the Antitrust Division and in the FTC. And over the course of the term, some of the things that the Trump administration did was take a more aggressive stance towards vertical mergers in the AT&T Time Warner case, which they ultimately litigated and lost, but they took on the case and took an aggressive stance on the case that I think surprised a lot of people coming from a Republican administration. They also took some unique approaches in challenging post-closing mergers, including mergers that were not reportable. In Otto Bach, the Department of Justice secured a divestiture 2 years after the merger closed. And they also, for the first time, engaged in binding arbitration with Novellus, where they arbitrated a dispute relating to the applicable product market in connection with the merger and acquisition. So I don't see necessarily a major sea change in what the Biden administration is going to do, but I do think it's going to build on what the Trump administration has done and continue to be aggressive in challenging mergers that it thinks are anti-competitive. And one thing to keep in mind too is any significant expansion or attempted expansion of the antitrust doctrine is going to run into a judiciary that is, for the most part, hostile to challenges that are initiated by the Justice Department relating to mergers. We talked about the AT&T and Time Warner merger that was litigated by the Justice Department and they ultimately lost, but also the Sabre Fair Logic merger challenge, that the Department of Justice litigated in Delaware and lost. That merger was eventually abandoned because of the UK Competition Authority. But no matter how you slice it, the judiciary is going to stand in the way of any major overhaul, any major changes that where they try to become more aggressive towards antitrust enforcement. Also, in the last administration, they announced new vertical merger guidelines within the last 6 or 8 months that I expect the Biden administration to continue to build on. As part of those merger guidelines, I think everybody expected there to be a treatment of vertical mergers that was generally favorable, and there was. But there were a few pieces of the vertical merger guidelines that I think would be appealing to kind of the new antitrust group of academics that advocate for a broader and wider approach to the antitrust law. So there are some pieces of those vertical merger guidelines that give justice and the FTC the ability to challenge vertical mergers where they think that it's going to be harmful to competition. And the other big piece that I expect will continue to grow throughout the Biden administration is the challenges to acquisitions of nascent competitors. And this is something that's really come to attention within the last few years, first in the tech industry and highlighted recently by Facebook's acquisition of Instagram. But over the last year or so, we saw challenges to Procter & Gamble's attempted acquisition of Billy in the women's shaving line, Edgewell or Schick's attempted acquisition of Harry's, also in the shavings, in the shaving line, Visa and Plaid and FinTech, and also Illumina and Pacific Bio in medical devices. And so this is a type of merger and a type of acquisition that I think is going to continue to come under a lot of scrutiny by the Biden Justice Department and the Antitrust Division, where these are going to be challenged and mergers will be challenged that might have been looked over in the past.
Yeah, and if I could add one thing, I think, Matt, you're exactly right. And the things that we're predicting what's going to happen, there's some steps along the way. We do not have, we'll soon have an attorney general, but then we need to have the assistant attorney general in charge of the division. On the FTC side, we have an acting chair. We're going to have a change in majorities, and we'll have change in bureau directors and the like. So we have yet to see who they're going to be. I mean, Macon Delrahim was his own person in virtually every respect and brought his attention to the enforcement of the antitrust law. So we'll have to see how that plays out and how the commission is staffed, and to see, we would anticipate, some more activism, as Matt said, but there are the limitations on how they're going to go. And the long-term professional staff, many of them are going to be there. They tend to stay around. So we may overestimate changes at the time of administration change.
I have a question, Matt or Tom. I noticed, the vertical merger guidelines had not been revised for a long time. I think they were revised in 2020, and the guidelines were, put in place in 1984. So what prompted, in your view, the issuance of the new policy at the end of the Trump administration?
I think, in my opinion, my perspective, I think it was the AT&T and Time Warner case that was litigated by the Justice Department, which they ultimately lost. But I think there was still a concern within the Justice Department, even though that they lost that case, that there could be vertical mergers that would be anti-competitive. And I think they believed that the AT&T Time Warner was one of those mergers, and that's why they brought that case. And so I think introducing the new vertical merger guidelines was trying to adopt a position and stake out a position that's consistent with the decision that we saw in that case by Judge Leon that was ultimately affirmed, and then but also allowing the Justice Department and the FTC latitude to go after and continue to pursue enforcement actions against companies and against acquisitions that it thinks is going to be harmful. And the ability for it to do that is a deterrent in and of itself, because a lot of these, for instance, the nascent competitor cases, those acquisitions were all abandoned after the Justice Department announced that it was going to challenge the acquisition. And so just the threat of being able to take enforcement action against a potential company because of an acquisition is sometimes enough to cause the acquisition to be abandoned.
Yeah, and I think also there was a perception in the antitrust community from outside the agencies that the old guidelines didn't reflect current thinking. And you look to the guidelines for a predictive basis, that if clients and companies are looking to a merger and they ask counsel, how likely is it, is there going to be a challenge and how do we work around it? If the guidelines are well out of bounds or out of sync with what the enforcers are actually doing, you don't get that predictive value. You don't get the benefit of what guidelines are supposed to be. So I think there was a lot of criticism of the existing guidelines, not right or wrong, but simply not reflecting what the agencies were actually doing.
That's fair. So along those lines of being in sync with what the agency's doing, especially with respect to the Biden administration, Matt, what other antitrust challenges do you see for M&A teams and legal and compliance departments that they're likely to face over the next 4 years?
So I think from a practical perspective, if you are in-house, whether you're part of the legal team, whether you're part of the compliance team in-house, or whether you're a business person as part of the M&A team that you've been enlisted on to evaluate a potential transaction, one of the first things I think that you need to consider is putting into place an antitrust risk assessment as part of the transaction early on. And what that is going to do is have you evaluate the antitrust risks associated with the potential transaction. And then that way you're able to guide the transaction in a way that's a little bit more thoughtful and a little bit more contoured to what the risk may be for the potential acquisition. And so as you start off and begin to think about what the acquisition looks like, and you think about this antitrust risk assessment, is the transaction reportable or is it not reportable? If it's not reportable, that doesn't necessarily mean that you're totally out of the woods. As I mentioned, the Otto Bach case that was challenged by DOJ was 2 years after the merger was consummated, or the acquisition was consummated rather, and the DOJ ultimately required divestiture. Just within the last couple of weeks, the Fourth Circuit was able to rule on a private case that was filed by a competitor, a private civil action, that ultimately resulted in a divestiture, despite the fact that the acquisition was not challenged by either DOJ or FTC. And so the fact that an acquisition may not necessarily be reportable doesn't mean that you're out of the woods from an antitrust perspective. But also, whether or not the action is reportable is not going to be the only piece of the risk assessment. Is this an acquisition that involves a nascent competitor? Is it an acquisition that's in the technology industry? Does it involve fintech, which is another hot issue right now? Is this an acquisition that's likely to draw scrutiny from the Department of Justice because that it's a 3-to-2 merger or a 2-to-1 merger? One of the issues that is traditionally problematic in dealing with mergers and acquisitions. And then once you have that risk assessment, that'll guide then the rest of the transaction and how you want it to proceed. Another issue as part of the due diligence process in the acquisition is ensuring that you have something set up to protect competitively sensitive information. And whether that's use of aggregated data relating to pricing or to customers, so that no one on both sides of the merger or acquisition can determine the pricing or sensitive customer data of the other, or you have a clean team of people who are not involved in pricing, not involved with customers. Or you use like a third-party consultant to come in and analyze this data, aggregate it, and report it back to you. But something to avoid the perception that you're using the M&A process to obtain competitively sensitive information from a competitor. And then also, depending on the risk of the potential transaction, you want to look at educating the M&A business team on hot documents. And as part of the M&A process, and particularly if the transaction's reportable, companies are required to file 4C documents, which are documents that relate to the evaluation of the transaction. And so educating the M&A team early on what types of documents to create, what type of language to use in connection with the evaluation of the transaction is going to save you a lot of time, trouble, and heartache down the road if you have to explain some problematic 4C documents to either the Justice or the FTC. Finally, if you have an acquisition that you think may be potentially problematic from an antitrust perspective, it's never too early to begin to think about what the merger agreement or the acquisition agreement is going to look like and how that's going to be negotiated. Do you need to include a divestiture clause in the agreement? Do you need to include indemnification or a termination fee in the event that the acquisition is challenged? Or is there a timing clause in the agreement that if the acquisition doesn't close by a certain date in the event of a challenge, the party has a right to walk away? These are all things to think about as you begin to explore a potential transaction. Gun jumping is always an issue too, to make sure that you don't begin to integrate the companies too early before a transaction is closed. But because of the aggressiveness or the perceived aggressiveness of the Biden administration, that's something that you got to be on top of early and make sure you're evaluating these risks and learning how to deal with them early.
Thanks, Matt. So we spent quite a bit of time talking about M&A issues. Other than M&A issues, what other hot button antitrust issues do you expect to see during the Biden administration?
I do think, and I'm not going to talk about the tech issues because I think that's a CLE unto itself of all of the issues that have come up in the tech industry, but I do think there's going to be some spillover effects from the tech industry. And what we're seeing both from Congress and I think even now really popular opinion is people are getting a little bit more concerned about dominant companies. And so I think there's going to be more of an emphasis on Section 2 of the Sherman Act, particularly where companies that are dominant or perceived to be dominant are engaging in things like self-dealing or self-preferencing, particularly with agreements that may not necessarily be they're arm's length agreements, but agreements that may not necessarily be totally fair from a market perspective, where you have a dominant company involved. And I think we're going to continue to see increased enforcement in antitrust labor markets. This is something that started under the Obama administration in October of 2016, when the Justice Department issued its guidance on antitrust guidance for human resources professionals. It's continued into the Trump administration with some civil lawsuits relating to antitrust issues in the labor market, where the Justice Department has brought civil lawsuits related to no poach agreements, and also increased enforcement by state attorneys general, where there's a lot of action right now related to non-compete agreements. And that's not traditionally antitrust or pure antitrust, but there's a lot of concern right now with the enforceability of these agreements as an anti-competitive device that companies are forcing on employees or on their labor market. And so as an action item, what I would take away from this is internally as to what to look forward over the next 4 years is that I'd take a hard look at my company on how I use non-compete agreements. And if I'm using non-compete agreements with employees that may not necessarily have access to really confidential information or information that's really going to damage my company if that person were to leave, I'd be taking a hard look at whether or not that non-compete is really something that's necessary, or whether it's just going to cause potential problems if you have an activist attorney general or from federal enforcement from the Biden administration. I'd also take a hard look at no poach agreements. And I know, Joan, this is going to be something that you're going to talk about a little bit more as part of your presentation, but there's a real, I think, driving force in the community right now, in the antitrust community, to eliminate these no poach agreements, which have been common for a long time, and it's really requiring a change in the way that companies think about things and do business.
So Joan, Matt already alluded to the no poach. What do you expect will happen with no poach, but also wage fixing antitrust cases in the Biden administration?
Yeah, Matt had talked about the guidance to human resources professionals in 2016. And basically that guidance, built upon what the DOJ was already doing, making it very clear that agreements among competitors that fixed wages, salaries, terms of employment were per se illegal, that the government did not have to show any kind of competitive effect. Similarly, as Matt said, they also dealt with agreements between competitors that basically barred hiring, recruiting, or soliciting each other's employees was, again, per se illegal. The guidance talked about naked poach, no poach, and wage fixing agreements, meaning that these agreements were separate between competitors, that they weren't ancillary to a larger collaboration agreement between companies, such as you might have in a joint venture situation, where the exchange of information could be justified under certain conditions, and Matt and I can talk about that. And the one thing that the guidance talked about was the fact that these agreements don't need to be in writing. They don't need to be explicit. They can be implicit. They can be proven by circumstantial evidence. And so it's important to keep in mind. And there's some nuances here that the DOJ and the FTC obviously know. So in that guidance in 2016, they did encourage companies to reach out to ask questions about conduct that could be at risk. What you saw right in this time, I think a couple of years later, was one significant civil case involving two companies that were involved in railway equipment. It was a no poach case where they basically decided that they weren't going to hire each other's employees. What happened in that case was there was a civil resolution by the DOJ rather than a criminal resolution. The guidance made very clear that the DOJ saw these agreements as per se illegal and wanted and indicated an intent after the issuance of the guidance to start charging them criminally. That case, Wabtec, was resolved civilly, but just recently in December 2020 and January 2021, we had two indictments come down. The first indictment was against a company called Surgical Care Affiliates. SCA ran outpatient medical facilities, and it agreed with another competitor in Texas not to solicit senior employees. Both of them agreed, and this went on for a long period of time, from like 2010 until 2017, so about 7 years, obviously a year after that guidance was issued. There was another competitor in Colorado, did the same thing for a 5-year period ending in 2017. These agreements were gentlemen's agreements. They were not in writing. The DOJ established the existence of the agreements largely by email traffic and indicted the company for it. Interestingly, SCA was also hit with a class action lawsuit filed in the Eastern District of Illinois, a proposed class action for the same conduct. So it's fighting on multiple fronts. The other case of interest is a case called United States versus Gendel, and that involved a naked wage fixing agreement. It involved a physical therapy staffing agency that worked with home healthcare patients. Obviously they were reimbursed by Medicare. The staffing agency was not making as much of a profit as they wanted on the rates that physical therapists and their assistants were charging. So the head of the agency, Jindal, reached out to other staffing agencies in the area, and they basically exchanged information. They agreed that they needed to make their rates consistent, and so all of them decreased rates. What was also interesting about that case is Jindal was approached by the Federal Trade Commission investigators, and he basically lied to those investigators, saying that he didn't, that the decrease in rates was a product of discussions in his internal team, that he wasn't exchanging any information with competitors. So he was charged with obstruction of justice as well. Another facet about that case is immediately after the indictment was issued, that particular U.S. Attorney's Office joined the procurement collusion task force that had been established by the Antitrust division. There are more than 30 participants in that task force, and it's focusing on anti-competitive behavior related to government procurement. So we expect that there's going to be more antitrust cases involving a connection with a federal government program. And as Matt referenced, state AGs have been very active in this space. They basically have, especially Washington State, which negotiated with about 200 companies so that they would take their non-compete, no poach provisions out of franchisee agreements nationwide. Other state AGs have gotten in the act. You had a group of 13 state AGs negotiating with companies in 2019 and reaching agreement to make sure that their franchise agreements didn't contain these kinds of clauses. So you'll see that on the state and the federal level. And it is, and we expect it to continue in the Biden administration, because the guidance came out during the Obama administration, and it has been rigorously used by the Justice Department and the FTC.
Yeah, Joan, I think it's fair to say in the enforcement community that it by and large believes two things. One, that there is a lot of this going on, and two, that is depressing wages, which is obviously a focus of this administration, is getting wages in line with economic growth. And I think, and they may be exactly right about the first of those, at least. My alma mater, Duke University, and the University of North Carolina medical centers got caught with a no poach agreement. And if UNC and Duke are motivated to do it, two schools that otherwise couldn't cooperate on what is North and what is South, I think there's a perception that it's out there, and there's a lot of it. And so I think it's in the compliance or in-house legal communities, I think the antenna should be there to see if you've got folks in your departments, in the talent management and otherwise, who are, as you said, Joan, kind of inching their way into these type of agreements. That could be a huge liability issue.
Well, that's such a great point, Tom, because think about how these discussions occur. They're not a senior executive calling another senior executive and agreeing to something. They can be much more nuanced. You could have human resource professionals that are meeting for coffee or meeting at association or industry meetings, talking about what terms of employment they're offering, what wages they're offering, and actually, in essence, kind of colluding about what's good and bad about what they're doing. And that could result in a reportable and criminal antitrust violation. So it's very important that healthcare professionals and those dealing with these issues be properly trained.
Yeah, and I've seen these agreements frequently, and it's really over the last 5 years that this has been, on the Justice Department's radar screen. But this is something I see frequently as part of settlement agreements involving litigation, where people want to institute a no poach as part of, you mentioned franchisees, but as part of vertical arrangements with suppliers or with customers. Where people want to put in a no poach. And I think whereas 10 years ago or 15 years ago, nobody would have given any thought to that. Now you've got to look at these things with a much more skeptical eye to determine whether or not this is one of those situations where it's allowed.
Yeah, you really need to look at that antitrust risk carefully, which gets back to Matt's point on risk assessment related to these things, because these kinds of issues come up not only in settlement, employment, and severance agreements, which single agreements are not implicated by the guidance. It really is those separate agreements among competitors that are implicated. But when you have a joint venture, or when you have a merger and acquisition situation, and you're exchanging data, you have to be very careful about how you exchange data. And as Matt said, whether it can be done in aggregating and anonymizing, or a specific collaboration agreement sets forth the terms and the reason that the data has to be exchanged. It's something that now your antitrust counsel needs to think about to mitigate that antitrust risk.
And talking about, antitrust risk, there's a new law protecting antitrust whistleblowers. Joan, can you tell us a little bit more about this law and any potential impacts that you could see it having?
Yeah, sure. It passed in 2020, and it's called the Criminal Antitrust Anti-Retaliation Act. The act applies to whistleblowers, and the term whistleblowers is really defined very broadly. So that's the first concern. It's not just employees of a company. It includes agents, contractors, subcontractors as well, who are reporting criminal antitrust violations, price fixing, bid rigging, market allocation. So it's criminal antitrust violations, either internally to the company or externally to the federal government, the antitrust division. And that it protects employees who reasonably believe that there is an criminal antitrust violation, and it prohibits employers from taking adverse personnel actions or other actions against agents or contractors, like termination for contractors, or for employees, suspending, termination, threatening them, harassing them, demoting them, those kinds of adverse actions that could be considered retaliatory. An individual can file a complaint with the Department of Labor. If the Department of Labor doesn't proceed within 180 days, the individual can bring a anti-retaliation complaint in federal district court. The difference between this whistleblower act and some other whistleblower provisions, like in the Dodd-Frank Act and false claims whistleblowers, is that the individual is not entitled to any kind of monetary award of what the federal government may collect. The whistleblower is only entitled to that which is provided for in a retaliation action, which would be reinstatement to the same status, back pay, special damages, including attorney fees and litigation costs. So it would be limited in that respect. The other thing that's different about this act is it's not available to those individuals who planned and initiated the criminal antitrust violation. And that's important because in some of these other provisions, you may be participating in the misconduct, but you can still be a whistleblower. Your award may be reduced, but it doesn't impact your status as a whistleblower. So that also is a big difference in the antitrust context. How do I see issues related to this act? Well, the first one is for those companies who really don't have a robust reporting system, and you'll know that by looking at the track record of how these whistleblower complaints are coming in. You need to start thinking about creating an enhancements for the reporting system, because you want your employee or your contractor to be able to have trust in that system and report it internally. It has really significant effects in the antitrust context, because if an employee does not trust the system and they go directly to the Department of Justice, it implicates whether or not a company can use the corporate leniency policy. Remember, first in the door companies that promptly report get immunity from prosecution. But if you've got employees going in before the company can do an internal investigation and quickly figure out whether or not they should report, that could cause problems for that company and moving forward under the corporate leniency policy. So that's very, the other thing I see is whistleblowers. What is planned and initiated? There's going to be litigation occurring as to what that means in the context of reporting an antitrust violation. If it's construed very broadly and excludes whistleblowers who participated in the misconduct but may not have been the primary actors, that could significantly impede the whistleblowers from actually making those reports. So we'll see how that is interpreted over time.
And, given this broad scope, I would say, or definition of whistleblower, what are some steps that I would say 2 to 3 steps that you would recommend to legal and compliance departments that should take in light of the likely criminal antitrust priorities of the Biden Justice Department?
Well, certainly go through your policies and ensure that where you have your whistleblower policies in place, that they're updated to reflect this new law and that they conform to, and you set up your procedures to, conform as well. Training is critical, and it's training not only at the board level, but also with those that need to know. The people in the business units handling pricing, procurement, individuals that human resource professionals, your compliance and legal departments all should receive training on this act and how to prioritize these complaints, because if they have they're going to be just per se serious and significant, especially if the complaints include facts surrounding the violation, so they have immediate credibility and they'll have to be dealt with quickly. Internal investigation protocols should be in place to immediately start an internal investigation, and because of the significance of a criminal antitrust violation, it's important that they be conducted under attorney-client privilege. And as Tom and Matt will tell you, if it's allegations that involve a multi-jurisdictional case, privilege can be very tricky because attorney-client privilege is not as robust in other countries as it is in the United States. For instance, in Europe, You have in-house counsel that really are not able to invoke attorney-client privilege. So it's important to structure the internal investigation to bring it into the United States so that our robust protections can be used when you're investigating the violation.
Thanks, Joan. Tom, Matt mentioned the spillover effect from the tech industries and how companies with higher market shares may see increased scrutiny as a result. What do you think will be the biggest privacy and data security compliance challenges under the new administration?
I think first we have to keep a perspective about this. Unlike some of the criminal laws and the antitrust laws, the executive branch has very limited levers at the federal level to impact privacy practice and policy and enforcement. We do not have a federal statutory authorization, right? The way we have under the antitrust laws and certainly under the criminal code. So what we have is, by and large, the Federal Trade Commission is the cop on the beat. We'll see a change in majority. No more than 3 commissioners can be from one political party. So we'll likely have a changeover in the commission lineup. We already have an acting chair of the FTC, and we'll have a Democratic majority. And so, at least looking at who's likely to fill those slots, it'll be an activist enforcement agency on privacy terms. But understand that's not necessarily new. The Bureau of Consumer Protection has been very active and has announced that it's going to be very active, and we believe it's going to stay very active in privacy enforcement. Emphasis on financial issues, responding to the pandemic frauds and the use to telemedicine, to the contact tracing and the like. So that this is not necessarily a new development, but understand you're simply going to have a little higher temperature on what's been a pretty high temperature activity in any event. And beyond that, because Congress has still not gotten around to giving either the commission or others specific statutory authority, there are limits that they're going to have. One of the developments could actually cut the other way. The Supreme Court has heard arguments on whether or not the FTC's use of the ability to obtain monetary relief in consumer protection cases, any cases, but particularly consumer protection cases, is valid. And there's some betting based on the oral arguments that it may go the wrong way for the FTC. And if the FTC loses the ability to get monetary relief in an enforcement action in federal court, you can believe that people are going to be less likely to negotiate payment of fees if the commission doesn't have statutory authority to get it. No one's that generous in handing money over in the course of an investigation. And so that's something that may cut against it and decrease some of the enforcement. We will see, and one of the things we're going to have to watch on the data security side, and it's a live issue, is that, as you know, one of the common ways people are infiltrated is with what is called ransomware. As the name applies, someone gets into your system, shuts it down, and steals information, and threatens to keep you shut down or to divulge your information unless you pay a ransom. And this is a Trump administration development that's going to carry over that will, in certain circumstances, make it illegal to make the ransom payments. It's a criminal statute, the OFAC regime, with very large civil penalties and criminal penalties. And we've worked in those situations where it's a rock and a hard place, where a company faces an existential threat to its business unless it pays the ransom. But if it pays the ransom, it may be violating federal criminal law. So I think that's an issue that we're going to have to watch, and we really hope that we get consistency from the federal government, understanding that no one wants to break the law, nor does anyone want to fund terrorism or criminal activities. But if the cost of that is going out of business, it's going to be a tough call for people. What we are going to see, and I think is something that we can touch on in a moment, is the activity from a different level, or 2 different levels. One is the states. The states are very active in their enforcement, and we are tracking, and we've sent a bulletin out on the new Virginia law, the developments in the California law, Washington law, and the like. And so I think that's something that the federal government will encourage, but until it replaces it, that's where a lot of the activity is going to be.
Given that the number of activities that are occurring in this space, what do you think companies should be doing now to prepare for the foreseeable future of privacy and data security?
Yeah, now, as I said, the state laws are there, and we're seeing them. And we've got some in front of us. You have the California Consumer Protection Act, went into effect last year. And we've got the California Privacy Rights Act, which is effective January 1, 2023, which seems like a very long time away from now, and it's not. We're already working with clients because it's a substantial change in how your advertising and marketing is done and how you build regimes around that. Virginia is coming online a lot like California, but not necessarily different. Washington, if they advance, and we've been waiting for several sessions for Washington to advance, would be, and it's Washington State, would be potentially November of 2021, which is an incredibly short period of time to comply, even if you've done the California work, because Washington looks differently, and we're looking at New York State and the others. So I think it behooves all of us to be tracking these laws pretty carefully. And we're working with clients because we may not need in March of 2021 to implement all of the changes that are going to be required. That what clients don't want to do is, because the pace is moving incredibly quickly in every industry, and how you market, how you reach consumers, and how you sell, and then pandemic world, how you do that electronically. So the business development, the marketing, the advertising, the customer acquisition functions and businesses are way out there, and they should be, they need to be. And so as they're building these systems, if they build it in a way that's inconsistent with these new regimes, a year or a year and a half from now, you have to rip those out. And you've got all kinds of third-party agreements. You've got all kind of data flows that you're going to have to untangle, and you may not be able to. So I think the wise move is to ingratiate the privacy planning into these other functions so that they're at the table and they're working on it. Because I can't overestimate or overemphasize how great this technology is and what's coming online. And for a company to miss out on that because they didn't do the privacy planning will be a double problem. You got legal compliance problems and you're behind your competitors. And so I think that's something that they really need to be doing. One area I'm finding that crosses over from the antitrust discussion that Matt and Joan had into the privacy discussion is the use of artificial intelligence and algorithmic business. It's there. It's not science fiction. We're working with companies who are doing it now, and the technology's there. On the marketing side, I know, as a matter of fact, from my browsing activity, that the advertisers aren't just figuring out where I was an hour ago. They're guessing where I'm going to be an hour from now, and they're usually right. My phone knows where I'm heading in 2 hours. It will tell me where I'm heading in 2 hours. And so the technology is already there, and it's being used. And it's being used as well for pricing, right? The algorithmic pricing, the machine learning, we've seen it work. I mean, I've seen it in operation, and it's tremendous technology. And so that depends on huge amounts of information, and some of it's very personal, and some of it's brought from, obtained from third parties. You need to do that. And these machines learn from each other. If two competitors in a market are using this kind of pricing, and their pricing arrives at the same point, you're going to have enforcers wondering about that. The Europeans are already studying this in great detail. The antitrust section of the ABA has already provided comments to that. So these algorithmic and machine learning concepts, you're going to see the marketing and privacy side and the competition and pricing side working together, because the systems only work if you merge those activities. And so I think that's something that if you want to get ahead of the curve a bit, and you also want to work with the absolute coolest technology in your business and have that fun, that's something that's going to be there. And of course, on top of that are all the international developments.
Tom, there's one issue that, speaking of the crossover between data privacy and antitrust, there's one issue that Joan and I have run into many times, particularly in multi-jurisdiction investigations or international antitrust investigations, and that's trying to manage competing interests of conducting a thorough antitrust investigation, particularly when the race is on to get in the door for corporate leniency, and then also trying to comply with data privacy regulations around the world. How do you manage those tensions from a data privacy perspective, and is that something that you run into frequently?
Yeah, and I will say, Tom, the DOJ doesn't have, the DOJ and the SEC sort of see the data privacy issues as something that the company needs to resolve. It's not their problem.
Exactly. Yeah, and we face this. It's, again, not necessarily new, but we're seeing a lot of this now. And the specific issue or the two specific issues. One is the protection given to the employees who's subject to the investigation, or maybe a subject of the investigation if that's where the conduct is, and then the laws against cross-border transfer of data. You know, the Europeans have declared, and they always will declare, that the Americans do not have adequate privacy protection, and so the transfer of data from the EU into the US, and probably the UK is from the UK to the US as well, is illegal. And there may be a legal limitation on the ability of the company to get the information. And remember, if I'm sitting here and I'm in Cleveland, Ohio, if I'm sitting in Cleveland and I use systems to access data in a data center in Paris, that data has been transferred to me. That's how the law treats it. So you've got to deal with the two issues. One is, can I even look at this information? Can I compel the individual to participate? And if I'm doing an internal price fixing investigation, and I'm suspecting a certain marketing person or executive in Europe, they may not have an incentive to cooperate with me, right? Because they're telling on themselves. So the deal with how can you compel or access their information, access the systems, and you've got to resolve that, and then getting the data here. The bottom line is we have situations in which we have mutually exclusive risks, that there's not a solution that is going to satisfy both the European privacy laws and the obligations you may have in to the SEC, an FCPA investigation or the like, and you're going to have to make a choice, right? And say, okay, I may get myself in trouble to some extent with the Europeans if I complete my investigation and make the fruits of that available to the federal government, because the risk of not doing that is so much larger. Joan, you're right about getting first in the line. So there's a lot of judgment calls to be made, and sometimes saying, you know, we're going to do the best we can with this and do what we have. And so it is. There is no rote answer to that question. It's always been, in my experience, balancing the risks you're facing.
I find it very interesting and challenging for companies, because when you hire local counsel in, let's say, a European jurisdiction, you can get very different opinions regarding what should be done, from all the way from this is the law and you can't transfer the data out, or there is nothing you can do here, to more pragmatic advice, interpreting the same law. So because of the, you know, there's growing enforcement in the data privacy area, but we're still not seeing it come to complete fruition. Also, you notice that other regions like Latin America they're increasingly focused on data privacy and looking at data privacy protections similarly to in similar regimes that or assessing whether or not they should employ the same regime the EU has.
Right, Brazil, Australia, and others. Mona, do we have questions before I prattle on anymore to make sure that we're not cutting anyone short?
I do not see any questions. If any of the attendees have questions, please feel free to start giving them to us. We have a few minutes left. But until I see any pop up, I'm going to ask one final question to Tom. You mentioned data flows. In your opinion, what are the prospects for maintaining unhindered data flows across borders moving forward?
Yeah, I don't think we're going to get unhindered, because they're not unhindered now, but it's a good way of putting it, Mona. Thank you. We're watching a couple of developments because so much of this is EU centric. And there's a few things that are going on right now. Brexit was a monkey wrench in a lot of things, but certainly a monkey wrench in this. Remember that there are regimes in which one can take what is illegal, transferring data from Europe to the United States, and make it legal. We lost last year one of those, the so-called Privacy Shield, which replaced the safe harbor. And Mr. Schrems, Max Schrems, I was a panel on him once, deceptively pleasant man who causes lots of problems, but successfully litigated in the European courts to a decision that invalidated the Privacy Shield, making the transfer of data from Europe to the United States much more difficult. We have for now, and I emphasize for now, what are called the standard contractual clauses, and the EU is updating, the EC is updating those. And that's a contractual agreement between two parties allowing the data to go from Europe to other jurisdictions, including the United States. It's cumbersome. It's not a systematic solution to it, but we're doing a lot of these now, so at least we can get the data flowing. Remembering, as I said, that the mere act of accessing it is deemed to be a transfer. And so when we work with clients on very sophisticated product development or marketing development operations, and because they want to run as a global company, making sure the data can flow to the United States, to your Indian engineering and help desk and the like, and your South American operations, wherever else it may be. Canada's implicated, Mexico's implicated. That it's a lot of thoughtful work to create the contractual structure to allow the data to flow. And that includes internally. I mean, if you've got affiliates, one in Europe and one in the United States, you've got to regularize that. You can't assume because you're affiliates, you can share information. And so it's been more complicated this year. And what Brexit did is that once the UK is outside of the EU, the ability for information to flow within the EU is maintained, but the UK isn't part of that anymore. So what was required, what's called an adequacy finding, that the European Commission and the European Union would find that the UK gives an adequate level of protection. They've given an interim decision, and we've got 6 months and a few months of that left, and the reviewing body has said, we believe the UK does. That's got to go and be adopted by all the member states. Why is this important? Well, so many American companies used the UK as their bridgehead into Europe. It's an English-speaking country, laws that looked a lot more like ours, and so for a number of companies, having the UK there, an English-speaking regime, that was the focus of getting data across from Europe to the United States. If that wall goes back up and we don't get the adequacy finding and we have other obstructions, then you're going to have to add one more layer, one more step to getting the data where you want it to go. So that's going to be interesting. And look, there are going to be challenges. The same, some people call them gadflies, others say privacy advocates, are going to be attacking some of these regimes, and we're going to watch that happen. Because remember, the underlying suspicion is not that people in this audience, the private companies, the industry, are the ones damaging privacy. It's our intelligence agencies. The gripe is, especially since the Bush administration, that our intelligence agencies are mining data is the reason given that data can't come to the United, or shouldn't come to the United States. And there's nothing anyone on the panel or in the audience can do about that. None of us control the intelligence agencies. And so it's going to be on the Biden administration. They're in negotiations. There's some hope that through their Commerce Department, that the tensions will be lowered and the cooperation will be higher, and we can get a more rationalized regime of at least recognizing the need for the data flows. So it'll be complicated, but it's something that if we pick two things to watch and for people to plan ahead for, one is watching the data flows to the extent you need it for your business, and the other is keeping a very close eye on the state laws. And if you think about that, sandwiches the topic of this discussion, the Biden administration, because there's one external and one in our federal system at the more localized level. But that's, I think, where a lot of the action is going to be.
Thanks, Tom. A lot of good stuff. I think we have like 2 minutes left, so I want to make sure I read the CLE code for those that are seeking it. If you are seeking the CLE for today's program, the tracking code is Biden CLE. It's all one word. Again, the tracking code is Biden CLE. If you are not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailing updates under the Publications tab. We'd like to thank you all for your interest in attending today's webinar. Our next webinar in the series, Transition of Presidential Change, will be held next Tuesday, March 9th at 2 p.m. Eastern Standard Time. The webinar will address government contracts and the Biden administration. Thank you all again. Enjoy the rest of your day. Stay well, and thank you to the panelists. It was a really fun and informative discussion.
Thank you.
Thank you.
Thank you.
Bye, everyone.